when does a spousal support obligation end in Virginia? The answer is it depends on what created that spousal support obligation. Was it by contract or by court order? If the spousal support was agreed to by the parties, normally the terms of the contract would control. And it's possible that a husband and wife, if they don't provide for termination or modification of spousal support, it might continue indefinitely. If it's by court order, spousal support will terminate upon the death of either party, the remarriage of the party who is receiving support. And by the way, there is an affirmative duty upon the spouse receiving spousal support to notify the payor spouse, the spouse who's paying the support, that he or she has remarried, and they have to send that to their ex-spouse at that person's last known address. And the third thing that might terminate a spousal support obligation could be cohabitation with another person, male or female, in a relationship analogous to marriage that continues for at least a year. Now, there is a higher standard. We see that intermediate family law standard, not just preponderance of the evidence, but the clear and convincing evidence is required to prove that that relationship exists and that support should be terminated. Now, support will not be terminated if a contract, again, doesn't provide for it, or provides otherwise, rather, or if terminating support upon cohabitation would be unconscionable, is the word in the code. And there is a lower standard for that, the traditional civil standard of proof of preponderance of the evidence. So a mere preponderance of the evidence, if the spouse who's receiving support can show that terminating support because of that cohabitation would be unconscionable, the support would not be terminated upon that particular event. So it's important, given the factors involved at work in terminating spousal support, that you discuss with your Virginia lawyer whether your spousal support obligation might be terminated.